Article 132, Appellate jurisdiction of Supreme Court in appeals from high courts in certain cases. Clause 1, an appeal shall lie to the Supreme Court from any judgment, decree or final order of a high court in the territory of India, whether in a civil, criminal or other proceeding, if the high court certifies under Article 134A that the case involves a substantial question of law as to the interpretation of this constitution. Clause 3, where such a certificate is given, any party in the case may appeal to the Supreme Court on the ground that any such question as aforesaid has been wrongly decided. Explanation: for the purposes of this article, the expression final order includes an order deciding an issue which, if decided in favor of the appellant, would be sufficient for the final disposal of the case. Article 133, Appellate jurisdiction of Supreme Court in appeals from high courts in regard to civil matters. Clause 1, an appeal shall lie to the Supreme Court from any judgment, decree or final order in a civil proceeding of a high court in the territory of India if the high court certifies under Article 134A. Subclause A, that the case involves a substantial question of law of general importance, and subclause B, that in the opinion of the High Court, this said question needs to be decided by the Supreme Court. Clause 2, notwithstanding anything in Article 132, any part appealing to the Supreme Court under Clause 1 may urge as one of the grounds in such appeal that a substantial question of law as to the interpretation of this Constitution has been wrongly decided. Clause 3, notwithstanding anything in this article, no appeal shall, unless Parliament by law otherwise provides, lie to the Supreme Court from the judgment, decree, or final order of one judge of a High Court. Article 134, Appellate jurisdiction of Supreme Court in regard to criminal matters. Clause 1, an appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of a High Court in the territory of India if the High Court, subclause A, has on appeal reversed an order of acquittal of an accused person and sentenced him to death, or subclause B, has withdrawn for trial before it itself any case from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to death, or subclause C, certifies under Article 134A that the case is a fit one for appeal to the Supreme Court, provided that an appeal under subclause C shall lie subject to such provisions as may be made in that behalf under Clause 1 of Article 145 and to such condition as the High Court may establish or require. Clause 2, Parliament may by law confer on the Supreme Court any further powers to entertain and hear appeals from any judgment, final order or sentence in a criminal proceeding of a High Court in the territory of India, subject to such conditions and limitation as may be specified in such law. Article 134A, Certificate for Appeal to the Supreme Court. Every High Court passing or making a judgment, decree, final order or sentence referred to in Clause 1 of Article 132 or Clause 1 of Article 133 or Clause 1 of Article 134. Clause A, may, if it deems fit so to do on its own motion, and Clause B, shall, if an oral application is made by or on behalf of the party aggrieved immediately after the passing or making of such judgment, decree, final order or sentence, determined as soon as may be after such passing or making the question whether a certificate of a nature referred to in Clause 1 of Article 132 or Clause 1 of Article 133, or as the case may be, subclause C of Clause 1 of Article 134 may be given in respect of that case. Article 135, Jurisdiction powers of the federal court under existing law to be accessible by the Supreme Court until Parliament by law otherwise provides. The Supreme Court shall also have jurisdiction powers with respect to any matter to which the provisions of Article 133 or Article 134 do not apply if jurisdiction and powers in relation to that matter were accessible by the federal court immediately before the commencement of this constitution under any existing law. Article 136, special leave to appeal by the Supreme Court. Clause 1, notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in the territory of India. Clause 2, nothing in Clause 1 shall apply to any judgment, determination, sentence, or order passed or made by any court or tribunal constituted by or under any law relating to the armed forces. Article 137, review of judgments or orders by the Supreme Court, subject to the provisions of any law made by Parliament or any rules made under Article 145, the Supreme Court shall have the power to review any judgment pronounced or order made by it. Article 138, enlargement of the jurisdiction of the Supreme Court. Clause 1, the Supreme Court shall have such further jurisdiction and powers with respect to any of the matters in the Union list as Parliament may by law confer. Clause 2, the Supreme Court shall have such further jurisdiction and powers with respect to any matter as the Government of India and the Government of any state may by special agreement confer if Parliament by law provides for exercise of such jurisdiction and powers of the Supreme Court. Article 139, conferment on the Supreme Court of powers to issue certain writs. Parliament may by law confer on the Supreme Court power to issue directions, orders, or writs, including writ in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them, for any purposes other than those mentioned in Clause 2 of Article 32. Article 139A, transfer of certain cases. Clause 1, where cases involving the same or substantially the same questions of law are pending before the Supreme Court in one more High Court or before two or more High Courts, and the Supreme Court is satisfied on its own motion or on an application made by the Attorney General of India or by a party to any such case, that such question are substantial question of general importance, the Supreme Court may withdraw the case or cases pending before the High Court or the High Courts and dispose of all the cases itself, provided that Supreme Court may, after determining the said questions of law, return any case so withdrawn together with a copy of its judgment on such questions to the High Court from which the case has been withdrawn, and the High Court shall on receipt thereof proceed to dispose of the case in conformity with such judgment. Clause 2, the Supreme Court may, if it deems it expedient so to do for the ends of justice, transfer any case, appeal, or other proceedings pending before any High Court to any other High Court. Article 140, ancillary powers of Supreme Court. Parliament may by law make provision for conferring upon the Supreme Court such supplemental powers not inconsistent with any of the provisions of this Constitution, as may appear to be necessary or desirable for the purpose of enabling the court more effectively to exercise the jurisdiction conferred upon it by or under this Constitution. Article 141, law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. Article 142, enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. Clause 1. The Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it, and any decree so passed or order so made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament, and until provisions in that behalf are so made in such manner as the President may by order prescribe. Clause 2. Subject to the provisions of any law made in this behalf of Parliament, the Supreme Court shall, as respect the whole of territory of India, have all and every power to make any order for the purpose of securing the attendance of any person, the discovery or production of any documents, or the investigation or punishment of any contempt of itself. Article 143. Power of President to consult Supreme Court. Clause 1. If at any time it appears to the President that a question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question to that court for consideration, and the court may, after such hearing as it thinks fit, report to the President its opinion thereon. Clause 2. The President may, notwithstanding anything in the proviso to Article 131, referred a dispute of the kind mentioned in the said proviso to the Supreme Court for opinion, and the Supreme Court shall, after such hearing as it thinks fit, report to the President its opinion thereon. Article 144. Civil and judicial authority to act in aid of the Supreme Court. All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. Article 144 are special provisions as to disposal of question relating to constitutional validity of laws omitted by the Constitution 43rd Amendment Act 1977. Article 145. Rules of court, etc. Clause 1. Subject to the provisions of any law made by Parliament, the Supreme Court may from time to time, with the approval of the President, make rules for regulating generally the practice and procedure of the court, including subclause A, rules as to the persons practicing before the court. Subclause B. Rules as to the procedure for hearing appeals and other matters pertaining to appeals, including the time within which appeals to the court are to be entered. Subclause C. Rules as to the proceedings in the court for the enforcement of any of the rights conferred by the Part 3. Subclause CC. Rules as to the proceedings in the court under Article 139A. Subclause D. Rules as to the entertainment of appeals under Subclause C of Clause 1 of Article 134. Subclause E. Rules as to the conditions subject to which any judgment pronounced or order made by the court may be reviewed, and the procedure for such review, including the time within which applications to the court for such review are to be entered. Subclause F. Rules as to the cost of and incidental to any proceedings in the court, and as to the fees to be charged in respect of proceedings therein. Subclause G. Rules as to the granting of bail. Subclause H. Rules as to stay of proceedings. Rules as to stay of proceedings. Subclause I. Rules providing for the summary determination of any appeal which appears to the court to the frivolous or vexatious or brought for the purpose of delay. Subclause J. Rules as to the procedure for inquiries referred to in Clause 1 of Article 317. Clause 2. Subject to the provisions of Clause 3, rules made under this article may fix the minimum number of judges who are to sit for any purpose, and may provide for the powers of single judges and division courts. Clause 3. The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution, or for the purpose of hearing any reference under Article 143 shall be 5, provided that where the court hearing an appeal under any of the provisions of this chapter other than Article 132 consists of less than 5 judges, and in the course of the hearing of appeal the court is satisfied that the appeal involves a substantial question of law as to the interpretation of this constitution, the determination of which is necessary for the disposal of the appeal. Such court shall refer the question for opinion to a court constituted as required by this clause for the purpose of deciding any case involving such question, and shall on receipt of the opinion dispose of the appeal in conformity with such opinion. Clause 4. No judgment shall be delivered by the Supreme Court save in open court, and no report shall be made under Article 143 save in accordance with an opinion also delivered in open court. Clause 5. No judgment and no such opinion shall be delivered by the Supreme Court save with the concurrence of a majority of the judges present at the hearing of the case. But nothing in this clause shall be deemed to prevent a judge who does not concur from delivering a dissenting judgment or opinion.